Oops.
The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you. And good morning and welcome to the Court of Appeals of North Carolina by way of WebEx or by YouTube. I'm Chief Judge Donna Stroud, head of the panel today, and I'm joined by Judge Hunter Murphy, who is on my virtual right, Judge Jefferson Griffin to my virtual left, because when we're in the courtroom, that's how we're seated. So now I get confused when we're online. Let's see, we have 3 arguments today, 3 cases for argument, and we are here with our first case for argument in the case of State versus Wilson. And we are ready to proceed. I think you've already said you were reserving 5 minutes for rebuttal, so we should have the clock set for that.
Good morning and may it please the court. My name is David Andrews. I represent Josiah Wilson. I urge this court to reverse Josiah's convictions. Now, I'd love to talk about all 5 issues in this appeal because they're important. They warrant relief in their own right, but 30 minutes might not be enough time. So I'm going to plan on focusing on primarily on the first 3 issues in the brief and move on as time allows to other arguments. With that in mind, I'm going to start with the jury selection issue. And as you noted, I'd like to reserve 5 minutes for rebuttal. So the big picture for the challenge for cause is how many times does a juror have to say he can't be fair in order to be kept off the jury? Mr. Keever, in this case, he's blunt. He says 7 times either he can't be fair or he favors the prosecution. And this to me is remarkable. It's as if he's taken truth serum. This is a juror being brutally honest about his ability to serve. The very first thing he says is that he can't be fair, and the gist of his concerns are that he's biased. Now, it's not unlike the previous juror who got up and said, the very first thing he said was just outright, I'm racist. And the judge immediately struck him for cause for obvious reasons. Why not do the same with Mr. Keever, who had a bias that was just as important? And sure, you know, the judge allows the prosecutor to ask him a series of questions, and Mr. Keever provides answers that the prosecutor is looking for. But at the end of the day, we're left with a juror who openly said, and this is a quote, "I'm very sympathetic to the victim and his family. It pains me to know that they're in this room hearing what's going on. I don't think I can get past that." This is a huge red flag. It's a clear example of bias. Mr. Keever should not have been placed on this jury. Now, you're going to look, obviously, at the back and forth between the prosecutor, Mr. Keever, and the defense attorney, and Mr. Keever. And I just encourage you all to keep all of those exchanges in context. I want to just point out for you one page that I think is relevant here that'll shine a light on what's going on. And it's appendix page 18 in my brief. You can look at it, or I'll just tell you the transcript page for later if you want to look at it. It's page 725 of the transcript. Down in the middle of this page, starting on line 15, the prosecutor is talking to Mr. Keever and saying, for example, and I think you said it yourself, he's sitting here right now, he's innocent until proven guilty. Mr. Keever says yes. Prosecutor says, and you understand that? Mr. Keever says yes. That's fine as far as it goes. But just a few lines earlier, this is the problem. This is the very top of appendix page 18, page 725 of the brief. Mr. Keever says, I think if I had to do it right now, at this point, I would be in favor of the prosecution. My point about this page is, sure, Mr. Keever intellectually understands the presumption of innocence, but when it comes time to put it in his own words, he just can't apply it, because right then, the state has not put on a shred of evidence. You can't be leaning in favor of the state. The presumption of evidence means if no evidence has been presented, you've got not only to lean in favor of the defendant, at that point, you've got to vote to acquit the defendant. And so this exchange here puts us in Hightower territory. This, in Hightower, you had a juror who said the fact that the defendant didn't testify would stick in the back of his mind. This is like that. This is a juror who cannot apply the presumption of innocence. And I don't begrudge Mr. Keever. I like Mr. Keever because he's honest, he's forthright. He just can't apply this presumption of innocence. The problem I have here is the judge's decision to allow him to serve on the jury. This is the judge, in a way, placing his finger on the scales in this case, allowing someone who is biased in favor of the state to serve on a body that is supposed to be neutral. This is a juror who's going to consider all the facts in the law, but who, out of the gate, leans toward one side. That's bias, and we don't want that in a jury, especially one that's deciding a first-degree murder charge. We need these jurors to be neutral, and we don't have that here with Mr. Keever. Okay.
Mr. Andrews, let me ask you real quick, how much of this is coming down to the abuse of discretion standard, in that we do have some rehabilitation of the juror later? The judge is the one sitting there judging his opinion of his or her opinion of the juror and the juror's credibility, the juror's demeanor when it gets to the rehabilitation stage. So if we have this rehabilitation showing up in the face of the record and the judge there to view what the demeanor is of the juror to see, is this person telling the truth now that they will follow the law, that they're going to be able to come in with an open mind, and the effect of the rehabilitation. Why shouldn't we give in to that discretion of the trial court judge that was actually witnessing the juror versus what we're reading in the transcript? I understand what you're saying about the beginning part, but I guess my issue is an abuse of discretion after at least what seems like a facially as rehabilitation of the juror.
Well, we have some rehabilitation. They are one-word answers to questions from the prosecutors. The problem, though, is that Mr. Keever keeps coming back to this problem with the presumption of innocence. He not only does he say at the beginning he's biased, not only does he say on appendix page 18 that he would vote in favor of the state before the state has put on any evidence. Flip back to the end after he's been rehabilitated. And I'm looking at appendix page 20, appendix page 21 in the appendix to my brief. This is pages 728, 727, 728. This is toward the end of individual questioning. He's already answered questions that, yes, he understands the presumption of innocence, but right at the bottom of 727, again, he comes back to, if I had to make a decision right now, it would still be very hard to make a decision. If I had to make a decision, I would lean toward being in favor of the prosecution. This is the last thing he says before this second challenge for cause. He can't get away from this bias. Yeah, he's explained a couple things showing that maybe he intellectually knows the presumption of innocence, but when he is speaking in his own words, his own understanding, that is really telling. That's what matters here. It jumps off the page. And even if the judge is right there in the courtroom, this is something the judge needs to be paying close attention to, because we're talking about the presumption of innocence. And Mr. Keever just can't get away from this inability to apply it. And so that's why this is an abuse of discretion. It's an abuse of discretion to let someone serve on a jury who consistently indicates he can't follow the law. Okay. All right. The next issue that I'd like to get to, if there are no more questions on the jury selection issue, is, well, I'd urge you to apply Hightower and remand this case for a new trial because it was error, it was an abuse of discretion to let Mr. Keever serve. Okay. Next. I'm sorry, were you saying something, Judge Murphy?
As to the Oglesby issue, which I think you raised by referring to Rule 10A1 in your opening brief, but then really hit home in your reply brief. Do you have any anticipation what the state's arguments may be against an Oglesby application to the preservation statute here? I know the state hasn't had a chance to respond, but is there anything you'd like to make us aware of that, the state may want to be heard on and considered here that may or may, cut against you or for you regarding Oglesby application to this statute, this preservation statute?
Yeah, thank you for bringing that up. The state in their brief, I think one of the cases they talk about is Garcelle, and they, this North Carolina Supreme Court has said you have to follow the statute carefully in order to preserve this issue. I don't know. I'm wary of getting into anticipatory arguments, but I suppose the state might say, well, hasn't the Supreme Court, by applying this, essentially said that the statute is constitutional? And, my answer to that would be no, because I don't think any court has ever put this statute side by side with the North Carolina Constitution. I think everyone has just assumed that it applies without really considering whether the General Assembly is encroaching upon the Supreme Court's exclusive authority to set up rules of preservation. There is a quote in Oglesby I'd urge you to consider when you're thinking about this preservation issue with this argument. They have this quote, and I believe it's on page 554 of the North Carolina Reporter in Oglesby. They're talking about Evidence Rule 103, and they say that that is manifestly an attempt to govern the procedure and practice of the appellate division as it purports to determine which issues are preserved for appellate review. And that's why it's unconstitutional. The same thing, the exact same thing is going on here, to the extent that 15A 1214 is dictating whether this issue is preserved or not. The General Assembly can't do that. This is the province of the Supreme Court. They've spoken on this with Appellate Rule 10. We have a rule of preservation. We don't need another one. Okay, and that's why I'm saying under Rule 10, this is preserved.
Now, the General Assembly has constitutional authority to prescribe our jurisdiction at the Court of Appeals. Is there an argument that this, by the phrasing of the statute, they're stripping us of jurisdiction to consider it without the prior preservation requirements, and therefore it's not something at least the Court of Appeals has jurisdiction to hear, regardless of Oglesby and its interpretation of the Supreme Court's rules in setting preservation?
I hadn't even, yeah, that did not even occur to me, but that is a good way of looking at this issue. You all obviously have jurisdiction to address legal issues and appeals. I guess my answer to your question would be the most straightforward view of this is looking at Bennett, Elam, and Oglesby. We have case law from the Supreme Court on this issue. That's the most straightforward path to get at this issue. Okay. All right, the next issue I would urge you to consider and grant relief on is the failure of the judge, the trial judge, to instruct the jury on second-degree murder. The problem here is that the evidence for the greater offense of first-degree murder, and specifically felony murder, was conflicting. Under State v. Whitaker, the evidence did not, quote unquote, inexorably and unerringly point to first-degree murder. The key principle here, when you're thinking about this argument, is that if the defendant requests an instruction on a lesser, the trial judge has to view the evidence in the light most favorable to the defendant. Looking at the evidence in the light most favorable to Josian contradicts the state's theory that he was guilty under acting in concert. Now, he repeatedly says, I counted 7 times in this interrogation that all he wanted to do was sell his phone. He didn't want to join Tink's plan to rob Mr. Finch. He says that multiple times. And then after the shooting, they don't rob Mr. Finch. He has $200 in cash on him. He has an iPhone on him. All of that directly contradicts the state's theory that this was a planned attempt to rob Mr. Finch. And so in the light most favorable to the defendant, we have a few things going on here. Number one, we don't have premeditation and deliberation. Number two, we have this evidence that directly contradicts felony murder. And we do have some evidence that Josian shot Mr. Finch with his statements to his friends. That gives us an inference of malice. When you put all of that together, that gets you, the jury, a pathway to second-degree murder. And the thing that I would ask you to remember, a key point here, when you're thinking about this issue, look at the jury verdicts. Something interesting happened. Yes, they convicted Josiah of attempted armed robbery and first-degree murder. What did they do with conspiracy? They acquitted him of conspiracy. Why would they do that? Josiah's statements, that was the only evidence. He's the only one pushing this idea that he didn't want to join in this, plan to rob Mr. Finch. That is a pretty good indication that the jury may well have gone for a lesser verdict here. They needed a safety valve in this case. That safety valve was second-degree murder, okay? Keeble talks
Do you have a case, or maybe you're about to get into it, I was going to ask if you had a case kind of lean us to this idea of looking at what was acquitted in consideration of this lesser included instruction.
I don't have a case directly on that. I'm glad you pointed that out, and I wish I did. I don't off the top of my head. But I'll say a couple things that sort of circle around this to some extent, Your Honor. Stavey Thomas, which I cite in the brief, they point out it's reversible error not to instruct on a lesser that's supported by the evidence. Poole and Barlow, which I also cited, they point out that a verdict for the greater offense doesn't cure the failure to give an instruction on a lesser. Keeble, which I was just about to mention, it talks about when a trial judge refuses to instruct on a lesser, the jury is likely to resolve doubts in favor of conviction. And that, I guess that might be the closest case to your point, Your Honor, because we've got a very stark choice here for the jury. On the one hand, they can acquit Josiah and he walks free, unconditional release. On the other hand, they can vote to hold him accountable on the only option available to them in a case where someone has died. That is a stark choice. Keeble says when a jury is faced with a stark choice like that, the pressure is so much that they're going to vote to convict. Okay? As I mentioned before, the jury needed a safety valve here. That acquittal on conspiracy is a pretty good indication that they would have gone for second-degree murder had it been available to them. Okay, and so again, ultimately, I asked this court to grant a new trial because the trial judge should have instructed on second-degree murder and didn't. The next issue that I'd like to talk about, another ground for relief here, is the admission of Josiah's confession. Okay. That confession, it should not have come in when you're looking at the totality of the circumstances, as you're supposed to do. Josiah gave this confession under duress. This was, a pressure campaign. The first red flag here is the officers only gain access to Josiah through deceit. And they're asking for the interview. The detectives, they tell the mother that he's only a witness to a larceny, at a mall, as if he witnessed shoplifting, for example. But that's not the case. He is a suspect in a first-degree murder case. The second cause for concern here is Josiah's age. He's young. He's 15 years old. He's a rising sophomore, so young that the officers found his picture in a yearbook. Haley v. Ohio speaks to this. They talk about, kids as young as 15 being an easy victim of the law. What are they saying there? They're saying that he's, a sitting duck for these harsh interrogation tactics. The third cause for concern is the pressure applied to Josiah by his parents. And this is significant. It gets back to the officers deceiving Josiah's mom. All she knows is that he's, a witness to a larceny. And so she allows the officers to talk to Josiah, thinking that all Josiah needs to do is tell them what he saw. She doesn't realize the stakes are far higher than that for Josiah. So she tells him to talk to the officers. As the interrogation progresses, she demands that he talk to them. She orders that he talk to them. She curses at him to talk to them.
Andrews,
Yes.
if I could ask, so at the beginning of the interview, that's the thing, but it does come out during the interview that it's something much more serious, and the parents continue. So what about the fact that, at that point, even after they know that it's something more serious than a larceny, they continue to encourage him to talk?
There's a very telling moment, Your Honor, in the interrogation where Josiah's mom says, "So Josiah, what happened to this guy that you were trying to sell this phone to?" And the detective says, "We're going to get to that." Okay. The gravity of the problem has not sunk in. Okay. Maybe it's sort of dawning on Josiah's mom, but it is not until the end of the interview when things sort of go haywire. You hear, I had that quote from his father. I'm not going to say it online. You're tripping. It's almost like his dad has a coronary right there, because they realize this is not just a larceny. This is not just a robbery. My God, someone has died. They don't know that until the very end, and it is striking. I just want to point out here, when you're reading this interrogation, if you're listening to it as I encourage you to do, what you're reading, what you're listening to, it's not just an interview. It's not just an interrogation. It's not just a confession. This, in a way, it's a family tearing itself apart. There's cursing, there's crying. Josiah's dad, freaks out. This is, devious stuff. The officers have set this interrogation up. They're pulling the strings here. The parents don't know how serious this interview really is. Josiah, he consistently denies involvement. The officers say that they don't believe him. When you put all this together, think about this when you're in chambers considering this issue. It's 4 against 1. 4 adults versus 1 child. Is it any surprise that Josiah confessed? Not at all. He was pressured to confess here. And I urge this court, I put in a memorandum of additional authority State v. Lynch, which came out recently. It was a voluntariness claim with an 18-year-old. That is a really good example of the totality of the circumstances of this court going through all the factors. That was an 18-year-old. He
Mr. Andrews, I have a question.
Yes, Your Honor.
So couldn't you argue that it would cut both ways having the parents present? I mean, isn't that a factor in favor of voluntariness of the confession, or the comfort level there? And if I'm getting your argument correct, you're arguing that the child, the 15-year-old defendant, should not tell his parents the truth. I mean, is that where we are?
Think about 7B 2101. Okay, it's a statute that says parents have to be present for a custodial interrogation. Okay, why do we have that statute? Why do we have that statute? To protect kids. Are the parents protecting Josiah here? No, they're not. They have turned into co-interrogators. I mean, it's one thing, and there's a tension that you're getting at. Parents do, I'm a parent. I want my kids to be good people. I want them to tell the truth. That is a conflict with Josiah's legal interests in this case. And the reason they want Josiah to tell the truth, Your Honor, is because the officers have let them know that he's only a witness in a larceny case. They don't know what the effect of him telling the truth is, because they don't know that he's a suspect in a murder case. Okay, this idea of parents protecting their kids, Josiah would have been better off without his parents. He didn't get the comfort and the protection here in this interview. Okay, I appreciate your concern. That's a very good question. Look, we're also dealing with the harmless beyond a reasonable doubt standard. The state has the burden on appeal of demonstrating beyond a reasonable doubt that this confession was harmless. Look, confessions are devastating. They're, the client's own words being used against them in court to convince a jury to convict them. The prosecutor used this confession against Josiah. In closing argument, he tells the jury, look, I'm going to quote this. This is on page 1229. Josiah told you that they were there. They had guns. He had a gun. He knew this was going to be a robbery. The prosecutor weaponizes this confession against Josiah. It's not harmless beyond a reasonable doubt. This is yet another ground for relief. It warrants a new trial in this case.
Mr. Andrews, I want to ask you regarding the trial court's order, appearing at record page 178, but really on 179 is where I'm looking. findings of fact 10 and 12. You don't challenge any of the findings of fact, which 10 says detectives did not use coercive interview tactics. And then 12 was the question by the detectives was not coercive or deceptive. Since that's not challenged, then what do we do with these arguments of, this false idea of why they were talking there, this build up to getting the answers they wanted, going through all these different steps? Is that, if those findings of fact aren't challenged, then how can we take into consideration a lot of your arguments regarding voluntariness?
Because that finding of fact only involves deception in the interrogation, not deception in setting up the interview. That's a distinct matter. That finding refers to how they were during the interview. Coercion, they were not coercive. That's really a conclusion of law. That's the whole game here. That's the whole question. Was this coercive or not? And so that's not really a binding finding of fact. That is the legal question that the judge is supposed to be deciding. Okay. And, under Haynes and Rollins, which I talk about in the brief, this is de novo review, and you're looking at whether the findings of fact and the unrefuted evidence support the trial judge's ultimate ruling about voluntariness. I see that I'm down to 5 minutes, and so I'm going to reserve the rest of my time for rebuttal. Thank you.
There we go. Okay. Yes, Ms. Jensen.
Thank you, Your Honor. May it please the court, my name is Marissa Jensen. I'm with the North Carolina Department of Justice, and I represent the state in this case. I'll start by addressing the issues in the order that Mr. Andrews addressed them, starting with the jury selection issue. As the court sort of explored with Mr. Andrews, the state's argument here is that, number one, this issue was not preserved for appellate review. And that's in light of 15A 1214, subsection I, subsection 2, which specifically provides that in a motion, the party should state that he would have challenged that juror peremptorily had his challenges not been exhausted. And the state argues here that that was the condition that was not fulfilled here. You'll see that in the case law, this is discussed. There are several cases in this line of cases, including State v. Garcelle, which is 363 NC 10, where the court finds that the defendant did not properly preserve this issue on appeal. And in light of that, the state would urge that, this issue was not preserved. To the point, the defendant made the argument that this was in direct conflict with Rule 10. And it certainly is not. I would point out that I think the big difference between the cases that defendant cites for that proposition, namely Elam, I can think of off the top of my head, that dealt with a rule of evidence that purported to preserve an issue for appellate review without objection. And that was in direct contradiction to Rule 10. That directly conflicts with Rule 10. This statute, 15A 1214, does not conflict with Rule 10. It lays out a very precise procedure. And in fact, that precise procedure helps to establish a finding, if there is one, helps the court to establish a finding for precedent. And you can see that because in the case that defendant cites, State v. Hightower, they actually discuss this. And they say that the defendant did follow this precise procedure that they were supposed to. And because they did that, we can find that there was prejudice because they stated that they would have challenged that juror had they had enough peremptory challenges. And so I would argue to the court that there is a reason for that provision. It certainly does not conflict with Rule 10, and it certainly applies here. Now, if the court were to decide that, the issue was preserved and we were going to address the merits, I would point the court, defendant mentioned page—
Ms. Jensen,
yes.
right before you move on to that, I wanted to ask a question, just following up on something Mr. Andrews was arguing. Do you agree or disagree with his reflection on the law that there have not been any constitutional challenges to this statute related to the same arguments that were made in Oglesby or Elam. Are you aware of any cases that have acknowledged a constitutional challenge to this statute and rejected it?
I don't think that there have been any express constitutional challenges in the cases that I read on this issue. However, as was sort of alluded to earlier in the discussion, I do think that the fact that they have repeatedly applied this statute, indicates towards a finding of constitutionality, and the fact that they've abided by it so precisely as well. You can see that. And I would also point out that, Hightower certainly, although instructive on this issue, is a 1992 case. I would point out to the court that that was distinguished by State v. Campbell, which is a 2005 case. And I would argue to the court that the facts of this case are more like the facts of Campbell than they are of Hightower. And I say that because, we're dealing with this issue of whether this juror has been rehabilitated. And I would argue to the court that this juror in question, Juror Keever, actually stated that he could give defendant a fair trial and follow the law many more times throughout this voir dire than he ever expressed any sort of equivocation. And Mr. Andrews pointed out several times, and I'll start with page 725 in the transcript, where the juror says, right now, at this point, I would be in favor of the prosecution. But I would point the court toward the next few lines of that dialogue, because immediately underneath that, where he says, if I had to make a decision right now, I would be in favor of the prosecution, the DA asks him some more questions. Will you understand that no one is asking you to make that decision right now? Yes. You understand that defendant's innocent until proven guilty? Yes. Will you follow the law? Yes. Will you listen to evidence from both sides? Yes. You will not hold it against the defendant if he chooses not to present evidence? No. That's not equivocal. And I would argue to the court that that exchange, that's just one part of the transcript that shows that he gave satisfactory answers to those questions. And, I don't think that the case law, I think there's room for some equivocation, as is discussed in Campbell, which is 359 NC 644. And in that case, the court states where a prospective juror can disregard prior knowledge and impressions, follow the trial court's instructions on the law, and render an impartial, independent decision based on the evidence, excusal is not mandatory. And I would argue that those are what the facts show here, not that this juror continued to assert this equivocation throughout the entire voir dire, such that he gave the judge an impression that he couldn't follow the law. And that's, again, going towards that abusive discretion standard, as was alluded to earlier. The trial court judge is the one that this standard affords great deference to the trial court judge for these reasons, because the trial court judge is the one who is able to see the demeanor of these people. He's able to make the best decisions in the context of what's going on in that courtroom at that time. And as far as page 727 and 728, that was discussed a little bit as well. The juror, again, says that if he had to make a decision right now, it would be in favor of the prosecution on page 727. But I believe, and I'll point out to the court, that was in response to a prompting by defense attorney about that hypothetical again. And the prompt was, well, if you had to make a decision right now, what would it be? And I would just urge the court to look at the pages that follow, pages 728 all the way up to 736, where it's the defense attorney that goes through this extensive back and forth questioning with this juror. She asks probably between 16 and 25 different questions. And I'm not going to read every single one, but among them, she's asking, do you understand that the state has the burden? Yes. That the defendant has no burden? Yes. Will each of you keep an open mind about this trial until all of the evidence is in? Yes. Do you promise to follow the law as instructed by the judge, even if you disagree with it? Yes. Can you hold the state to its burden? Yes. Do each of you promise not to require the defendant to prove anything? Yes. And I would urge the court to just look at that entire line of questions and those 7 or 8 pages to see that there was never any more equivocation after the prompting by the defense attorney about that hypothetical situation. And I would also point out to the court that I don't think that any of this case law has some sort of requirement that these jurors know the law. I mean, these jurors are lay people who don't know the proceedings. They don't know procedural. They don't know criminal law. You know, he's expressing these initial feelings that he has because he thinks that it's the right thing to do. But I think that in and of itself, especially when it's followed up by such a clear, unequivocal response to these questions, that it certainly doesn't amount to anything that would require dismissal. And I think, again, you have to look at that with deference to the trial court judge under that abuse of discretion standard, and look at whether that trial court judge's decision was so manifestly unsupported by reason and so arbitrary that it could not have been the result of a reasoned decision. And I would argue that that certainly wasn't the case here. And in light of the case law, a State v. Carr is another Court of Appeals case, 229 NC Act 579, where the facts are similar to those here. In that case, the juror mentioned having a friend that was murdered and feeling that there were legal loopholes that allowed the defendant to get out of crimes. And she stated that she might not be able to put her feelings about that aside and didn't think she could be fair and impartial. But at the close of that voir dire, she stated that she would vote in accordance with the facts presented at trial and the judge's instructions on the law, which is just like the case here. And that juror was rehabilitated. And I would urge the court that those facts are more like the facts here than they are in Hightower. I'll move on to the next issue that the defendant addressed, which was the issue about the jury instructions. And I would argue to the court that the evidence here was not in conflict. The evidence here tended to show that the defendant, acting by himself or in concert with another, killed the victim during an attempted robbery with a dangerous weapon. The evidence showed that he was the one who arranged the purported sale through the Let Go records, including the deception or lie that he told the victim that he had kids. The defendant argues that he told the detectives that he planned to sell his phone. And that was an issue that came up, and that this was a repeated statement that he planned to sell his phone. I would urge the court that when you look at the transcript of that interview, the initial statements, first of all, the defendant states, when the detectives ask him if they know why they're here, he states that he does, right off the bat. So everything that follows, I would urge to the court to look at, because he does start off with the story, well, I was planning to sell my phone. And he does say on page 70 and 71 and 72, I wanted to sell my phone, I wanted to sell my phone. But he also states that he knew that Tink was wanted to rob this man. He says that he was with Tink and Monty when he met the victim and that they all had guns, although he doesn't initially admit that. He says that he planned to give Tink some of the money, planned to break him off some of the money. He stated that the victim had pulled money partially out of his pocket and it was folded. He says that he saw Tink point a gun in the defendant's face. And he said the victim turned to run because he was fixing to get robbed. And I would argue to the court that all of this shows that there's no conflicting evidence that defendant knew of the intended robbery beforehand and chose to stay and participate. And even on top of this, you have the defendant's statements to Ashanti Gatewood and Travis Moore. His statements to Ashanti Gatewood were that he killed and robbed someone. And his statements to Travis Moore were that he killed someone. In addition to the statement to Ashanti Gatewood, there was the forensic cell phone evidence that he had actually deleted those statements to Ashanti Gatewood. And I would argue to the court that, you know, all of this does not amount to conflicting evidence. And I
Ms.
think
Morrison, you focused a little bit on the deleting messages. Is there any case law related to somebody's actions in deleting messages or deleting, communications that would be suggestive that that's something we should consider in terms of evidence against the defendant?
on that particular point of deleting messages, I don't believe so, Your Honor, not that I've seen. However, with regards to specific case law, I would point the court to State v. Gwynn, which is 362 NC 334. That's a 2008 North Carolina Supreme Court case. And they said there that there was no error by the trial court and defendant was not entitled to lesser included homicide offenses because the evidence of the underlying felony, which was robbery with a dangerous weapon there, was not in conflict. And I would argue that that case is similar to the facts of this case. There, in light of all of the evidence that came in at trial, there is no alternative theory that a jury could have found defendant guilty on. And defendant focused on the fact that he was acquitted of the conspiracy in his argument. Now, I would urge the court to focus on the fact that they convicted him of the attempted robbery with a dangerous weapon. The fact that they acquitted him of the conspiracy, and I don't know, obviously, we don't know why they acquitted him of that, but I will point out, I believe the indictments for that conspiracy charge stated that the agreement was with DeMonte McCain, and for whatever reason, Tink was not included in the indictment as far as who the conspiracy or agreement was with. Now, again, I don't think that's matters in this context, but I would argue to the court that, again, the fact that they actually convicted him of the attempted robbery with a dangerous weapon is what's instructive. I mean, the elements of robbery with a dangerous weapon are that the state has to prove that the defendant, either by himself or with another person, intended to rob that person, that the defendant or another person with whom he was acting in concert had a firearm in his possession, that the defendant, either by himself or acting together, used or threatened to use that firearm in such a way as to endanger or threaten the life of the person that was intended to be robbed, and that the use or threatened use of a firearm, either by defendant or by another person with whom defendant was acting in concert, was calculated and designed to bring about the robbery of that person and came so close to bringing it about that in the ordinary and likely course of things, the robbery would have been completed had it not been stopped or thwarted. And again, I think that is the most compelling evidence here, that they did convict him of that underlying felony. And yes, are there deflections of culpability or deflections of guilt in the defendant stating, I really wanted to just sell my phone? Yes, but does that amount to conflicting evidence on the underlying felony such that lesser included instruction should have been given? No, it doesn't. And I would argue to the court that one of the cases defendant cited, which is State v. Thomas, the facts are totally distinguishable here. And that in that case, the facts, that is an example where there was some kind of conflicting evidence on the underlying felony. And there was testimony by another person in that case that the defendant did not want to join in this plan, that she disapproved of the person that was shooting this gun. In that case, it dealt with a bunch of defendants riding around in a vehicle together, firing a gun out the window, and the homicide occurred when a victim was struck inside of her residence. Those are facts that support some sort of alternate theory. These are not. And I would argue to the court that State v. Gwynn is instructive on that. One last point on this issue, I would argue that even if this court were to rule that it was error not to give the lesser included offense here, that error would not rise to the level of prejudicial error. The defendant would not be able to show prejudice from that. And I think the biggest evidence of that is that there's no, again, and the case law talks about this, there's no reasonable possibility that the jury would not have convicted him on this. And I think, again, that points toward the fact that they did convict him of the attempted robbery with a dangerous weapon. And State v. Brewington, which is 343 NC 448, stands for that proposition. The court said there that under those facts, a reasonable possibility did not exist that the jury would have convicted defendant of a lesser included had the jury been given the opportunity to consider voluntary manslaughter. And I would put to the court, that's the situation we have here. I'll move on to the confession issue. The defendant argues that the defendant here gave his confession under duress, and he focuses on a couple of the issues here. The false pretenses under which the officer set up the interview, the defendant's age, as well as the pressure by the defendant's parents. I'll start with the fact that the detectives set up this interview, telling the defendant's mother that it was an investigation of a larceny. And as the court knows, there's lots of case law on this subject, and the case law says that trickery or deceit by officers does not make the confession inadmissible. The defendant has argued to you that there's a difference here. There's a difference between trickery and deceit in the interrogation tactics and in setting trickery and deceit in setting the investigation or the interview up. I would argue to court there's no authority for that. There is no separation there. Frazier v. Cupp, which is 394 U.S. 731, as well as State v. Jackson 308 NC 549, both deal with this notion that trickery and deceit, although not condoned, standing alone, do not make a confession inadmissible. In Frazier v. Cupp, the court said the fact that the police told the defendant falsely that his associate had confessed is, while relevant, insufficient to make an otherwise voluntary confession involuntary. And that case was ultimately affirmed. And I would argue
Jensen, if I could ask, I think one of the, and of course we see a lot of cases with officers using trickery and deceit, and basically just misrepresenting things in interrogations, and the law has approved that for whatever reason. But here, where especially this is the parents who are supposed to be in the role of helping to protect the juvenile, is it any different that the officers are misrepresenting things to the parents? And doesn't that basically make them, give them a large disadvantage in trying to look out for their child if they're presenting this as, he's a witness to something relatively minor that happened at a mall versus murder?
Yes, Your Honor. And I think that in the context of this particular situation, and especially looking at the dialogue of the interview as we have it, that might have been an issue had the parents, again, from the very beginning of this interview, the very first question was, you know why we're here, don't you? And the defendant says, yes. And they say, are you comfortable talking about this in front of your parents? And he says, yeah. And I would argue.
Well, he said that, but the parents don't know. They think they're talking about a larceny.
Right. And I would argue that once they start going into the course of events, because they sort of walk through it, and the defendant's telling him what's happening, how this was set up, they're getting further and further into it. The parents are getting more of an idea of what's going on. And certainly by the time that, I think it was talked about when they said, well, what happened to the man? And the detective said, well, we'll get to that. By that time, they had a very good idea. And they're urging him to tell the truth. Yes. Are they bullying him? Are they coercing him? I would argue to the court that they're not. Do they admonish him to tell the truth? Yes. But there's also case law to that point that says that by the officers or by parents, that's permissible. And one of the cases to that point is In Re DAC, which is 225 NC App 547. That's a 2013 Court of Appeals case, which stands for the propositions that actions by a juvenile's parents who are not acting as agents of the police do not constitute governmental coercion and do not preclude admission of a juvenile's inculpatory statement. And I would argue that that's instructive here. And again, I wouldn't even characterize this as the parents bullying him into confessions. I think it was discussed earlier that that there are these unchallenged findings of fact here, and I think those ultimately control. And I don't think that there were any findings of fact that were made at any time that his parents were taken advantage of, or that they didn't understand the situation, or that they acted as agents of the police and coerced him, or didn't act as agents of the police and coerced him. The defendant also talks about his age as being an area of concern, and he cites Haley v. Ohio, which is 332 U.S. 596. And I would point out to the court that the court in that case actually states that the fact that defendant is youthful will not preclude the admission of his inculpatory statement absent mistreatment or coercion by police officers. And in that case, the facts were totally different in that case than they are here. In that case, the court looked at not only the defendant's age, but when he was questioned, how long he was questioned, the fact that he had no one with him in that case, which is something that a lot of these cases focus on, as well as the callous attitude of the police. Those were all factors taken into account there. In that case, the police kept the defendant incommunicado for 3 days. His mother wasn't allowed to see him for 5 days. And the facts here are just totally different. I mean, the detectives went above and beyond to make sure that the defendant had people present, not just one, not just two, but I believe there were 3 family members present. The interview was conducted at his home to make him feel comfortable. And again, I would argue that, you know, they knew what was going on the further this interview went, and they could have stopped it at any time. And there's not any reflection of any of that in the transcript. Not one time did they say, wait, this is enough. This is over. We're not talking about this anymore. They wanted to hear about it. Now, I don't think that you can make the argument, you know, a lot of the case law focuses on the fact that these people of young ages did not have parents with them. So I don't think you can then turn around and make the argument that, well, this particular defendant shouldn't have had anybody with him because they weren't helpful to him. You know, especially in light of the case law that says unless they're acting as agents of the government, which was not the case here.
But doesn't the fact that they were tricked into bringing their son to this interview under false pretenses make a difference in terms of their mindset and whether they're able to effectively still be a parent and advise their child? You know, if you go into a conversation with one mindset of what's going on and then they get thrown completely upside down, how are they still in that parental mode when they've had no ability to reflect or think about how they're going to deal with this themselves, much less how they're going to counsel their child? Isn't that a big portion of why we want attorneys or parents there to be able to counsel their children and respond to how the law works or how the child's going to interact with the law? And if that's been thrown upside down, why should we find that that's a valid police tactic here, and say that the parents were even really there? Because, I mean, they were completely thrown for a loop and thrown upside down here.
Well, I would argue to the court that, you know, again, as this interview went on, they understood that this was a totally different situation that they knew nothing about. But I would also point out to the court that in the case law that discusses, you know, these tests for voluntariness of a confession, for totality of the circumstances, it doesn't talk about necessarily requirements that the parents be present so that they have a chance to prepare the child or counsel the child. I mean, certainly that is one of the things that it intends to remedy. But I don't think, again, I don't think the fact that they didn't know what was going on initially in and of itself makes this some sort of factor that could overcome all the other factors to make this not a voluntary confession. I don't
Well,
think
it's not really a lack of knowledge. It's complete open deceit, right? I mean, it's a straight out lie as to why the conversation is going to happen. It's not, hey, we want to talk to your son and they don't get any information. It's, we're giving you this story. This is why we're talking to you. This is where you think this conversation is going to be. And now we think your son shot somebody in the back during a robbery. That's a huge difference on the effective role of a parent, is it not?
I would just say that the case law would say otherwise, I believe, because the case law upholds situations where you have these officers lying to defendants and telling them, well, your co-defendant snitched on you. I mean, he told us that you did it, and that was not true. And you know, again, those cases were upheld, and I would argue to the court that it's similar. It's a similar notion. It's a similar idea here. And the fact that it took place with the parents initially in setting the interview up does not completely distinguish it or make it fall outside those cases that have held that those tactics are okay and help, and in and of themselves do not make a confession voluntary. And so in light of all of those things, in light of all of the authority cited, I would ask that the court find no error. Thank you.
Mr. Andrews?
Thank you, Your Honor. I'm going to go in reverse order here, and I'm going to be a little scattered, but I'm going to try to make some points here. The state was just talking about, for example, deceit with the parents. In and of itself, that is not enough. You don't look at these factors in and of themselves. You look at them in the totality of the circumstances, okay? The state also mentioned that the officers went above and beyond to help Josiah have this comfortable atmosphere. I'm paraphrasing, I know. If they went above and beyond, why did they lie about the purpose of the interview? That's not going above and beyond. That is deceit here. The state mentioned in re DAC for the proposition that parents are not governmental actors. Spano and Colum, which I talk about in the brief and the reply brief, directly refute this. Third parties are relevant for voluntariness arguments. In Spano, it was a friend, a guy named Bruno, who the state relied on, cops relied on to extract this confession. In Colum, it was the defendant's wife. Parents are relevant here for this analysis. Moving up to second-degree murder, I want to talk about State v. Brewington. The state talked about Brewington for prejudice. Brewington does not apply. The reason is the trial court gave an intervening instruction on second-degree murder. The defendant wanted voluntary manslaughter. The Supreme Court said you're not prejudiced because the jury didn't go for that intervening lesser. We don't have an intervening lesser included instruction here. It was all or nothing. Okay, moving up again. The state for second-degree murder relied on the verdict for attempted armed robbery to say that there's not a reasonable possibility of a different outcome. That verdict is and exemplifies Keeble. In order to hold Josiah accountable in a case where you had two polar extremes, not guilty or first-degree murder, they had to convict Josiah of attempted robbery in order to hold him accountable for first-degree murder. They didn't have the safety valve of second-degree murder. That verdict for attempted robbery doesn't really help here. I think the more telling aspect, as I mentioned, was the acquittal of conspiracy. That is a good indication.
You keep saying safety valve. I mean, are you basically asking for jury nullification there? What's the theory of second degree that's being asserted? I don't, when in the evidence.
State v. Thomas is your roadmap, Your Honor. Okay, that is where statements that the defendant made to another witness and to officers provided a basis for the verdict for the lesser offense. And the key thing here is you have to look at the evidence in the light most favorable to the defendant, okay? In this case, there is some evidence, for example, that Josiah shot Mr. Finch. That gives you an inference of malice, okay? That malice is a pathway for a verdict for a jury of second-degree murder. And we also have all this other evidence that conflicts with the state's theory that Josiah was part of this plan to rob Mr. Finch. You have to view the evidence in the light most favorable to the defendant. Okay, let me go up to make a couple points here. Looking at the jury selection issue and looking at, the state is saying that the defense attorney needed to say she would have used a peremptory if she had had one. If you look at page 736 of the transcript, it's true she didn't expressly say this. But the judge, after all these challenges for cause, the judge says, you've challenged Mr. Keever. It's my understanding you've not challenged Mr. Rojas. The defense attorney says, that's correct. I'm satisfied with Mr. Rojas. After all that questioning, she makes that statement. That is a pretty clear indication she would have used a peremptory on Mr. Keever if she had one, okay? The prejudice here is a juror serving on the jury who is not and cannot be neutral, okay? The last questioning after the challenge for cause is really the defense attorney. She's challenged Mr. Keever twice. She's stuck with him, okay? She's trying to make the best of a bad situation and trying to get him to understand the presumption of innocence. I'm out of time. I ask this court, please grant relief here. You have many avenues. A new trial is warranted. Thank you.
All right, thank you very much for the arguments. Adjourn.
This session of the North Carolina Court of Appeals is now adjourned.
Thank y'all.
Thank you.